Okay, it's 3 o'clock. I hope that those of you who are able to tune in are finding your review is proceeding as you had planned. I'd be interested to see how views and things on these videos are going to go up as we get closer to Tuesday. Though I have seen that a lot of you are using review books, and I'm really glad about that. I think that's a great strategy because I think the practice questions in those are really good. And so I just encourage you to prepare as best you can given the time that you have, and if these videos or some other resources are the best for you, then that's great. Today we're reviewing civil liberties and the Bill of Rights. Civil liberties and civil rights. And the biggest thing about civil liberties is that those relate to the Bill of Rights, the first 10 amendments to the Constitution. And those are about the protections that are granted, and those are called civil liberties. And then the second half of this unit is about civil rights, which is protections against discrimination. So both of those are relevant to our discussion today. So one thing we didn't recognize is that, at least I didn't recognize until I started teaching this class, actually, is that the Bill of Rights and the Constitution, but specifically the Bill of Rights, was only considered to be a protection for you against the federal government. It did not extend to the states. And that had been upheld in 1833 by the famous case Barron versus Baltimore, where it said the Bill of Rights only pertained to the federal government. That was not overturned until 1925 in the Gitlow versus New York case, where they actually said that parts of the 14th Amendment, as cases come up regarding those liberties, that those liberties can be extended to the state governments, protections against the state governments as well. So Gitlow versus New York began that process, and then after 1925, we have all these cases that help pull up different liberties to now be selectively incorporated into the body of protections you have from both the federal and the state government. So the 14th Amendment has the Due Process Clause, and it's through the Due Process Clause that a lot of these civil liberties are granted. So let's kind of go through them, and I'm going to use my review text as well, because here's my piece of advice about court cases, okay? You can just dang drive yourself insane about court cases. When I was at training for this course, they said that only the most basic court cases are necessary to answer the free response. For example, if there's a court case in a question, it's usually pick one of the following 3. And within those 3, there's probably going to be a court case that you know. If you don't know one of them, that's okay. You still have 2 other ones. It just will limit your flexibility and opportunity. So just don't drive yourself crazy about the fact that you're going to see court cases that we didn't talk about in class. To this day, I still see court cases that I don't know, and somehow I've managed to get a master's degree in history education, so I think it's going to be okay if you don't know every single court case that every single review book happens to talk about. So just don't let that discourage you. I really do feel like the ones we studied in class would be the ones that would be the you gotta know this on the test, and the other ones would just be nice to know and give you more flexibility. Okay, so freedom of religion is in the First Amendment, and remember there's 2 parts of freedom of religion. There's the Establishment Clause, which says that the government should not establish an official religion, and then there's the Free Exercise Clause, and it says that citizens will be free to worship or not worship as they please. So let's talk about the Establishment Clause. Yes?
Can I have something sweet to eat since Sissy got some?
Yes.
Yay!
Yay, okay. The Establishment Clause, most important test or case that goes with that is the Lemon versus Kurtzman case in 1971. Okay, another thing, it's called the Lemon test. Another thing that's important is that you don't need to talk about the background of the cases on the test. Never more than a sentence, if at all. You need to talk about what the result of the case was, or how it manifested itself, and how it affected the effect of the case, not the background of the case. All right, so in the Lemon versus Kurtzman case in 1971, they established a test called the Lemon test for making sure that a law did not establish a religion. And it has 3 parts. First of all, the law has to have a secular legislative purpose. So it has to have some reason why the law was created, and it can't be related to religion at all. Second of all, it can't advance or inhibit religion. And thirdly, it can't have excessive government entanglement with religion. So for a law to be okay, it has to pass this 3-part test. And if it can't pass the test, then it can be struck down. Also related to establishment was the Engel versus Vitale case in 1962, which bans prayer in school. And in general, whenever there's been a lot of court cases that have come forward with symbols in public displays, and in general, the court has ruled that a religious symbol can be a part of a public display as long as it's one of many symbols and it communicates a historical or cultural message. So the devil is really in the details when it comes to religious symbols in public displays, I would say. All right, then related to the free exercise clause. In 1988, we have this Employment Division versus Smith, the peyote case. And it basically said that it's fine if a law indirectly affects religion, as long as that was not its intent and it's not specifically aimed at religion. So, for example, in the peyote case, they were basically saying you can't use peyote as a part of your religious ceremonies. Our drug laws are not intended to interfere with religion, and it's not specifically aimed at religion. The intent of our drug laws have other goals besides interfering with Native American religious ceremonies. So that's related to free exercise as well. The Supreme Court has, in several different cases, though, protected religion and people's free exercise of it. So in a famous court case, they said that Amish kids you don't have to go to school after 8th grade in Amish communities, and that went against the laws that said you have to go to school until you're 16. And so they actually upheld the fact that since Amish children stay in their communities typically and they have economic activities that they can participate in, that it's okay if they skip school, if they do not go to public school, as most children do after a certain age. I'm trying to remember the name of that case. Let me see if I can find it real fast. Because it did seem kind of important. Not super important, but worth knowing. That case was called... Ah, here it is. It was called Wisconsin versus Yoder. Wisconsin versus Yoder in 1972. So that's a case that's in my review text. They've got Lemon versus Kurtzman, Wisconsin versus Yoder, and Employment Division versus Smith. Okay, and Engel versus Vitale in that text. So that relates to... Oh, also they've said that Jehovah's Witnesses cannot be required to salute the flag since that's against their religion, and they've allowed conscientious objectors based on religious grounds. So they do protect people's free exercise as well. But they have, through Employment Division versus Smith, they've also, in some ways, allowed the law to inhibit your free exercise. So there's definitely a balancing act here in terms of what the court is doing related to free exercise and establishment. All right, then we have freedom of expression. In general, the court has ruled over time that they are not for prior restraint. Prior restraint equals censorship in their minds, and they really don't like censorship. They do think after the fact you can sue for damages, and that's a better way to deal with when people use poor judgment in terms of what they express. In 1919, they established kind of the standard for freedom of expression in the Schenck versus the U.S. case. It basically says that you cannot speak in ways that create a clear and present danger. So this is the whole yelling fire in a movie theater that might lead to a stampede, that might hurt people in an immediate way. And they said that kind of speech is clear and present danger and is not allowed. And therefore, if there's any civil or criminal law, civil cases or criminal laws to limit that kind of speech, that will be upheld. They also talked about obscenity, and in 1973, in the Miller case, they created a test for obscenity. It's called the Miller test. They said obscenity, 1, appeals to a prurient interest in sex. 2, it shows patently offensive sexual conduct specifically defined by an obscenity law. And 3, it lacks literary, artistic, political, or scientific value. So once you have one of those three things, then those could qualify as obscene speech and therefore can be limited by law. It has to have all three of them, actually, in order to be considered obscene. And so that's the test they apply from here on out. Now, there's also speech that can be considered libel. Libel is statements that are malicious and damage a person's reputation. And then also slander, which is just spoken defamation. So libel is written, slander is spoken, and there have been some court cases that have helped clarify how we're going to define that in American law. New York Times versus Sullivan said that you can, if the newspaper gets it wrong and they print things that are wrong, they can only be sued if we know that they knew that their statements were untrue and that they actually intended harm. So newspapers actually have quite a bit of coverage in terms of not getting sued for writing the wrong things. They have a pretty high standard to prove if they want to get sued on the basis of just printing things that were inaccurate. It means, of course, for their branding, they don't want to print things that are inaccurate, but if they do, it's hard for them to be sued on that basis alone. All right, then you have symbolic speech, and in the Tinker versus Des Moines case, they ruled that students can wear armbands, and that is allowed symbolic speech. Also, in Texas v. Johnson, they ruled that you can burn the flag. So they have given quite a bit of protection to American citizens who want to express their political views through symbol or through the burning of the American flag. All right, then we have commercial speech. Commercial speech is regulated by the FTC, the Federal Trade Commission, and the idea is that you can't lie about your product or make false claims, and you cannot advertise an unlawful activity either. So you can't advertise that you run a prostitution ring or you have marijuana for sale on a billboard or something like that. And so all that commercial speech is overseen by the FTC. And the idea is that it's a governmental interest to protect the people against unfair claims related to products. So that's commercial speech. Then you also have broadcasting speech, and it can be regulated by the government as well through the FCC, the Federal Communications Commission. And the Red Lion Broadcasting Company versus the FCC said that they would regulate TV and radio stations more than they would newspapers because the frequencies are limited. There's an unlimited number of newspapers that anyone can print. We can have as many newspapers as people want because there's no limit to the pieces of paper that can be created in the economy. But there is a limit to the number of frequencies that can be sold on television and radio. And so therefore, they think since there's a limited supply that we need to make sure that the broadcasters that are using them are acting responsibly. So that's when they started to restrict obscene words. That was upheld in 1978. But in U.S. versus Playboy Entertainment Group, they said that they have to use the least restrictive remedy available when censoring broadcasting. So as technology advances, then least restrictive is kind of a moving target. For example, one way now we try to do least restrictive is by putting a 30-second delay on live broadcasts, and then censors actually sit at an award show, for example, where people are speaking extemporaneously. They'll have a 30-second delay where then the censors can just bleep out the words that are offensive, but not change the whole quality or way in which the award show is produced. Okay? So that would meet that standard under the Playboy Entertainment Group case. All right, then we have freedom of assembly, and the freedom of assembly is guaranteed in the First Amendment as well. It says you have a right to assemble. They can put what are called time, place, and manner restrictions on your assembly, and that's to make sure you have bathroom accommodations, public order, security, and traffic is not impeded, those kinds of things. They've also said in freedom of assembly that abortion protesting, that they can put distance and picketing limits on abortion protesters, and that they don't allow picketing to happen in private neighborhoods. So that's where they limited assembly as well. There are some important cases I saw in one of my review texts that I thought were interesting. One is Thornhill versus Alabama in 1940, where they said that strikes are not unlawful. And typically strikes happen outside a workplace where the workers gather to protest. They said that those were not unlawful in the 1940 case Thornhill versus Alabama. Then in Cox versus New Hampshire, some Jehovah's Witnesses tried to march without a permit, and they said they're requiring them to get a permit went against their religious beliefs. And the courts actually said, no, the permit thing is reasonable and required, and it has to be done. So that's another reason for the time, manner, and place restrictions. And then we had Lloyd Corporation versus Tanner, which clarified that you're not allowed to assemble on private property. And this was a shopping mall. In 1972, they said shopping malls are private property. So if you do want to gather publicly, it needs to be in public land or, but not privately owned land. And then the Boy Scouts case of 2000, Boy Scouts versus of America versus Dale, it actually clarified that if you, the Boy Scouts did not want to allow gay members or leaders into their association, and they said that that was fine, that they didn't have to since it was a private organization. So those were some other assembly cases. We also have, that's also association though. So assembly and association are kind of the same idea. Another famous association case is the NAACP versus Alabama, and that says that those organizations cannot be required to turn over their membership lists to the government. That cannot be required. All right. Then we also have some attention given to defendants' rights. And those, of course, are related to the 5th, 6th, and 7th Amendments of the Bill of Rights in the Constitution. And almost all of them have now been incorporated and apply now to the federal and state and local level. So we have search and seizure. First of all, we know that search warrants require probable cause. And here's the conditions under which police don't need a warrant. So if probable cause clearly exists and the officer can articulate why they think that it's probable that a crime was taking place, then they don't have to get a warrant. If it protects an officer's life, they don't have to get a warrant. If it is material relevant to a crime, and they know the crime and they know that that material was used in the crime, then they don't have to get a warrant. If someone is a suspect and that is material is within their immediate control, they don't have to get a warrant, or they don't have to get a search warrant. And if someone is about to be injured or is pending injury, the officers can enter that dwelling without a warrant. But otherwise, you have to get a warrant, and you have to use proper due process in order to do a search or seize your property. If they don't do that, then the exclusionary rule says in Mapp versus Ohio in 1961, the Mapp versus Ohio case said if they use illegal means to get the evidence, then they can't use it in court. And that is called the exclusionary rule. We did see after the attacks on 9/11 that the Patriot Act brought in some unusual cases where you could have like warrantless wiretaps of phones, and that has still proven controversial, and we're always kind of renegotiating that every time there's a sunset clause on the Patriot Act. And they've created FISA courts, these special courts that hear those cases and are super secret and not known in general by the public. So the Patriot Act has kind of ushered in this new era of concern about search and seizure. All right, self-incrimination is under the 5th Amendment. It says you cannot be forced to testify against yourself. And that was stemming from the Miranda versus Arizona case in 1966, which said you have to be read your rights. Later in the Nixon administration, they walked that back a little bit, and that's only if you're in custodial interrogation, which means you are being held by the police in a location and you are not free to leave. Then that is when they have to read you your rights. You also have a right to counsel, and that is the 6th Amendment. And in Gideon versus Wainwright in 1963, they said you needed to be provided a lawyer if you could not afford one. And that has now been incorporated down to the state level as well. Remember in class, though, we looked at how different states have different means by which they obtain lawyers for indigent clients and how they pay them, and that's an area that looks like it's under significant reform, that it could stand some closer inspection, since in the states they're getting vastly different qualities of legal representation. All right, trials. They have, federal courts have juries of 12, and habeas corpus rights. They have to inform people of their charges. They have to give them a speedy and public trial. And this all was challenged when we started rounding up suspected terrorists after 9/11 and putting them at Guantanamo Bay. And so that these modern situations, both the Patriot Act and the enemy combatants that are at Guantanamo Bay, they have all posed new questions about the degree to which these principles are being upheld by our current protocols. I will say this, though. The test is at least 5 years old. Every question has been in development for 5 years. So I don't think any of that more modern stuff will necessarily be on the test, particularly concerning Guantanamo Bay. I would doubt that would be on there. All right. Then you have cruel and unusual punishment. And those cases are usually related to capital punishment. And the first one is Furman versus Georgia. It said that you can't have they did a study and they looked at all the capital punishment decisions across the United States, and they found out that oftentimes the way that the sentence was applied was racist and arbitrary, and they ordered a halt to all death penalty punishments in the nation until a less arbitrary method of sentencing was found. And so that was had a pretty chilling effect on the death penalty until the states could make a more compelling case about why their death penalty protocols were fair. And then in 1976, North Carolina, this is interesting, in Woodson versus North Carolina had tried to make mandatory punishment for certain crimes, and that was trying to make the death penalty more fair, because of the way it had been inconsistently applied. They thought this would be the way to solve that problem. But the Supreme Court actually rejected that approach, and they said that mandatory death sentences are actually unconstitutional. So the death penalty is okay, they're just looking for it to be fairly applied and also not to be blindly applied. Seems to be what they're getting at there. In 1976 in Gregg versus Georgia, Georgia was finally able to convince the court that it had come up with a careful and fair system for trying capital offenses, and so that allowed the resumption of the death penalty in America. So for about 4 years, we didn't have that many states that were actually applying the death penalty because of this new standard that had been created by the court. And then in 1987, we had a court case called McCleskey versus Kemp. And they said just because the death penalty, it is demonstrated how it's inconsistently applied, that does not violate the 14th Amendment. So the Supreme Court is not seeking perfection, it seems, in the application of the death penalty. And so there seems to be a balancing act there. In Roper versus Simmons, though, in 2005, they actually said that the death penalty is unconstitutional for people who, at the time they committed their crime, were minors, even if they were charged as adults. So we do see some relief for anyone whose crime was committed while they were a young adult. And then in Atkins versus Virginia in 2002, they also say you can't sentence someone to death who's mentally handicapped. So lately they've created these other loopholes related to people who may not be of sound mind or a mature mind in death penalty cases. Okay, then we have the right to privacy. The right to privacy is not actually in the Constitution. There's no amendment I can point you to. Instead, it's implied. Its existence is implied by the Free Exercise Clause, by the Search and Seizure of the Fourth Amendment, and the Due Process Clause of the 14th Amendment. So over time they have... they think these are implied within the Constitution. In 1965, you had a case about this that was called Griswold versus Connecticut, and it said you had a right to privacy about contraceptive use, and that contraceptives were legal, and that your use of them was entirely up to you. In 1973, we had Roe v. Wade, and it established the right to a legal and safe abortion in America in the first trimester of pregnancy. It says the states can regulate abortion in the second trimester, but and they can actually ban abortion in the third trimester. Though lately cases have focused on if the birth of the baby threatens the mother's life, they have allowed for some of those to continue. So you can't ban every single abortion in the third trimester. But those that are elective, you can. But they have made concessions for the life of the mother. Then in 1992, in Planned Parenthood versus Casey, they made the standard for laws restricting abortion lower. Before, they'd had the higher standard of strict scrutiny, that if they were putting any law that was going to limit abortion, they put strict scrutiny standard on it. But then in 1992, they lowered that to an undue burden. And so since then, we've seen kind of a proliferation of abortion laws that have made it increasingly difficult for women to access abortions practically. Things like waiting periods, and in North Carolina now, ultrasounds that have to be done, and you have to listen to the baby's heartbeat. And now there's a question of if those kinds of things place an undue burden on the mother or not. Whereas before, they would have probably been struck down under strict scrutiny. So that's the difference there. All right, so that kind of sums up civil liberties and the way in which all those civil liberties have been slowly incorporated down to the states through the selective incorporation process. Okay? Next, we're going to look at the civil rights portion of this unit. And all of the civil rights protections stem from the 14th Amendment. This is one of the civil rights amendments that was passed after the Civil War. And it guaranteed equal protection of the laws and equal protection of life, liberty, and property for all. And if a law discriminates against a group, then there's 3 different levels of scrutiny that the court will apply to those laws that are restricting a specific group. Okay? Racial distinctions are inherently suspect. The court says that the minute you start dividing or discriminating against people on the basis of race in American society, this is inherently suspect given the racist social system we created in America. So, in order for you to make a law that restricts or discriminates against people based on race, it has to be necessary. Like, there's no other way to accomplish that purpose, and it has to be the least restrictive way. So it's a very high standard, and very few of those laws make it past that standard. For gender, they have created what's called the medium standard, and it is less strict than inherently suspect. And it is called, it says that the law or the discrimination has to bear a substantial relationship to an important governmental goal. So, that's it, the substantial relationship to a important governmental goal. And if you can meet that standard, then you might be able to have laws that discriminate on the basis of gender. Then we have other, like age or wealth discrimination. That has to be reasonable, rational to a legitimate government goal, but is a lower standard than gender or race. Okay? So let's talk about some of the racial based civil rights decisions in the past. In 1857, really one of the most stunning court rulings ever in American history was Dred Scott versus Sanford, which said basically, if you're black in America, not just a slave, but black, that you have no rights, that you're not a citizen of the United States. And it also said that, oh, by the way, slaves are not only not citizens, they're also property, like a piece of furniture. And so they have even less protection than anyone else. Then the 13th Amendment ended slavery. The 14th Amendment gives them equal protection. But in 1896, the Plessy versus Ferguson ruling kind of backtracked on the hope of the Civil War amendments. And that's because they said as long as you could have separate facilities, but they had to be equal. And that was the separate but equal doctrine. And that's going to create social segregation in America by law. It is acceptable. And that will not be overturned until 1954. And so between 1896 and 1954, we had separate facilities for whites and blacks, separate schools, separate libraries, only whites could go into restaurants, separate water fountains, This whole separate and supposedly equal, but rarely so, doctrine ruled. Then in 1954, under the Warren Court, NAACP lawyer Thurgood Marshall represented Linda Brown in the court case Brown versus Board of Education, where they said that no, just by separating people, you're inherently meaning that they're not equal. And that's when we began the massive racial integration, desegregation of our society. Then in 1971, it went further, and it said, in the Swan versus Charlotte Mecklenburg Schools case, it said that just going to the school closest to you in your neighborhood school is not really going to accomplish desegregation because we live in segregated housing. White people tend to live in white neighborhoods and black people tend to live in black neighborhoods. So the schools were still substantially segregated, and the Supreme Court saw how this was not in the long-term interest of our increasingly diverse and integrated society. So they said through Swan versus Charlotte Mecklenburg Schools that we should bus students across the districts to try and better racially desegregate our schools, and that was an acceptable remedy. Didn't mean you had to do it, but it meant if you chose to do it, it was an acceptable remedy to try and make sure that your schools were effectively desegregated and therefore protect you against civil rights claims by parents who felt the schools were not desegregated. Then we had the passage, already had the passage of the Civil Rights Act of 1964 that was passed by Lyndon Baines Johnson, and it said that you could not discriminate in public facilities on the basis of race, color, national origin, religion, and gender. And so it said that if you, under the Civil Rights Act of 1964, if you did segregate your schools or discriminate under these categories, that they would use fiscal federalism to exert influence on you, and they would cut off your funding. And this is where we're at with HB 2 right now, is they have ruled under the Civil Rights Act of 1964 that the way in which we're treating transgender people is unconstitutional, and on that basis they can cut off the funding to our schools. Also, the Civil Rights Act of 1964 said you can't discriminate against people in public places and in public businesses. And so McDonald's cannot discriminate on the basis of race. Now, keep in mind that private clubs can, the Carolina Country Club can discriminate on the basis of race. Colleges and universities that do not receive federal funding can discriminate. So Meredith College can only accept women if they so choose. So the Civil Rights Act of 1964 does have its limits in terms of public versus private. It does say that you cannot discriminate in employment, and they created the Equal Employment Opportunities Commission to ensure that there is equal access in employment. And the Civil Rights Act will also then be supported by later voting rights provisions, which we're getting ready to talk about. Okay? The right to vote. Historically in America, it was first only granted to white men with property. And then in the 1820s and 30s, the state started to extend the right to vote to all white males. It was not until the 15th Amendment after the Civil War that they gave black males the right to vote. And then once segregation hit, they basically used literacy tests and poll taxes to, even though theoretically black people could vote, and women could vote starting in 1920, both black and white, the way they functionally kept black people from voting was through poll taxes, grandfather clauses, and literacy tests. The poll tax said you had to pay to vote or register to vote, and the literacy test said you had to take a test to prove in order to vote. That test was not just a reading and writing test, by the way. It was much more difficult than that. But the grandfather clause was kind of like the cherry on top. It said you didn't have to take the literacy test or pay the poll tax if your grandfather could vote in 1860. And there were no black people whose grandfathers or relatives could have voted in 1860. So, the 24th Amendment is the first thing to address this, and it's not until 1964. And it said that we were no longer going to have the poll tax in federal elections. And then in 1965, just a year later, we passed the Voting Rights Act of 1965. That's after the March on Selma and the Civil Rights Movement's efforts. It got rid of the literacy test. And it also was a really successful attempt on the federal government to affect change in a very narrow and definable way. And so they actually sent voting registrars down into the South, and they couldn't make any changes to their voting protocols without getting approval from the federal government. And this is why even today, whenever we make changes to our voting protocols like voter ID, the federal government can always step in under the Voting Rights Act of 1965 and strike those ideas down. So there's always this interpretation, particularly in the South, under the Voting Rights Act of 1965 about any changes we make to our voting plans. All right. Also, we saw, as a result of the Voting Rights Act of 1965, that law encouraged, to as great a degree as possible, for us to draw congressional districts that were as representative of minorities as possible, like trying to create a majority-minority district, for example, to make sure that black people would actually be elected to Congress. We did this for a while, but I think the courts decided finally we had gotten a little bit out of hand, particularly in North Carolina. One of our districts that followed I-85 was very, very suspicious in terms of its shape, and it did not show compactness. And so in 1993 in Shaw versus Reno, they actually ruled that we had gone too far in North Carolina, and that district was unconstitutional. And then in 1996, there were two more cases, Shaw versus Hunt and Bush versus Vera. The Bush case was in Texas. The Shaw versus Hunt case was in North Carolina. And it said, again, that our lines for our districts had gotten too convoluted. So there's a very fine line here with the Voting Rights Act in terms of how we draw districts too, and the degree to which we take race into consideration when we draw them. Okay? Then we have other minority rights. I'm sad to report, but I guess I need to be practical, that I see a lot of attention given to women, but not a lot of attention given to Native Americans, Hispanics or Latinos, Asian Americans. I'm just not seeing anything in the review text about that. So I don't know if I'm disturbed or relieved about that. A little bit of both, I guess. So on your review sheet, it does say that in 1924, Native Americans became citizens, and in Title II of the Civil Rights Act of 1968, they actually applied the Bill of Rights to tribal governments. Santa Clara Pueblo versus Martinez in 1978 gave greater self-government to Native Americans on their tribal lands. I have seen a test that talked about Korematsu versus the United States. That's a pretty important court case that actually said it was constitutional to round up people of Japanese ancestry, who, citizens or not, it didn't really matter. They had done nothing wrong, but they thought during World War II that it was fine to round them up and put them in prison. And that was upheld by the Korematsu versus the United States case. All right, so let's just talk a little bit about women, since that does seem to have a pretty big piece of real estate in most of the review texts. In 1920, the 19th Amendment gave women the right to vote. And then in the 1960s, we get a second feminist wave, where attention was given to arbitrary gender-based classifications. In 1971, there was this court case. It was called Reed versus Reed. And in state law, for years, they had given preference to men being the executors of people's estates when they died. And in Reed versus Reed, they said that that's arbitrary, and there's no reason why men are more capable of settling an estate or being an executor of a will than women are. So that removed that arbitrary classification. In 1976, in Craig versus Boren, they established the medium scrutiny standard for gender classifications that we talked about earlier. And then in 1972, Title IX and the Higher Education Act said that you can't, if you're a college, you cannot discriminate on your spending, and that if however much you spend on men's sports at the college level, you need to spend on women's sports. And so this ruling was in 1972, but they didn't really start enforcing it until 1988 through the Civil Rights Restoration Act. They actually said that they're going to cut off all funding to schools that violated the law. And that's when they started eliminating many less popular men's sports, and that led to like a backlash. They've also started providing scholarships to a lot more women in less popular women's sports like crew or field hockey. And so that led to a bit of a backlash against Title IX. And then they have here the Lilly Ledbetter Fair Pay Act in 2009. And it closed a loophole that limited lawsuits if you were being discriminated against in your first paycheck in pay. And the Ledbetter Act expanded those limits and now allow you to sue based on any discriminatory paychecks, not just your first one. And yes, it's the case that most women don't realize that they're being discriminated against in their pay until much later. And so giving a woman any time she wants when she realizes she's being unfairly paid to sue, that's what the Lilly Ledbetter Fair Pay Act of 2009 accomplished. Okay. Women in the workplace. That's Title IX. Let's talk a little bit about sexual harassment. They created a standard for sexual harassment that says that if a hostile environment is being created, that does constitute sexual harassment, and it can range from suggestive remarks to attempts to coerce sex from a subordinate. And while it is difficult to prove legally, they did at least give some indication of a standard for proving sexual harassment, and that standard is called the hostile environment standard. We've already talked about abortion to a pretty good degree. Some other major civil rights advances that we have not talked about include the Age Discrimination Act of 1967. This is about aging and civil rights. And it says that you cannot discriminate on the basis of age, and the only exception for that is that if your job is physical in nature. And it also banned that mandatory retirement. That there used to be compulsory retirement in America at the age of 65 or 70. And now they phased that out because they said it did not meet the rational basis test. That if you can do the job at 90, why should you not be able to do the job? So they had to apply it to the specific person and the job and not just make these arbitrary cutoffs. Okay, then we have the disabilities, the Americans with Disabilities Act, and that's really important. In 1973, they started to define that if you couldn't access something, that was actually a form of discrimination. And in 1975, they made it clear that all children are entitled to an appropriate education, and therefore, if you are not providing that, the federal funds can be cut off for schools. So that's gotten a lot more schools to pay attention to learning disabled children and provide them with appropriate modifications. In 1990, the Americans with Disabilities Act required employers to make reasonable accommodations for disabled people and not discriminate in hiring. They've also, if you remember in class, we talked about how based on how large your corporation is or the size of it, that they will expect you to spend a certain amount of money to make your building or those kinds of things accommodating. But it's kind of on a sliding scale. The smaller your business is and the fewer employees it has, the less they expect of you. But the larger and more wealthy your business is, the more they expect of you. And they also expect all state governmental buildings and all federal governmental buildings to be within compliance to the ADA. All right. Then we had, gosh, it's interesting. My text doesn't talk about gay and lesbian rights, but I got to believe that you've got to at least know Lawrence v. Texas. Lawrence v. Texas was in 2003, and it struck down sodomy laws and said that what private consenting adults do in their bedrooms is no business of the government's. And then in 2015, gay marriage was sanctioned by the Supreme Court. I forget the name of that case. I don't think it won't be on the test anyway because it's so recent. But right now I've noticed that a lot of us who claim to know something about civil rights, we still haven't internalized the name of that case. It's like Oblinger or something like that. All right, then we have some affirmative action cases. Remember, affirmative action is efforts to bring about disadvantaged groups and make sure that they have increased employment, promotion, and admission opportunities. And the 1960s, we started affirmative action, where they tried to give preferential treatment to women and minorities. And women were by far the greatest benefactors of those laws. But in 1978, they started limiting them. They said that you can't set aside a number of seats in a freshman class for minorities. That is too discriminating, or it's like reverse discrimination in a way, and it wasn't discerning enough to pass the smell test. So in 1995, we'd also been doing these things called contract set-asides. If you remember, we tried to look at this in class a little bit, where another form of affirmative action was if the federal government was hiring a business to do something for the government, they would set aside a number of contracts just for minority-owned businesses. And in 1995, in Adirond Constructors versus Pena, they raised the standard for contract set-asides to that they had to be narrowly tailored and that they had to have a compelling governmental interest. So they just kind of raised the standard for when you could use contract set-asides. And you had to be able to articulate how you were meeting that standard through the law that you passed, which made those laws a little less common. In 1996, there was a proposition passed in California called Proposition 209. And through majority rule, they banned state affirmative action programs. This is an example of majority rule versus minority rights. It's usually assumed that just because the majority might want to take someone's rights away from them, that doesn't mean that it's right, and the courts usually step in to stop that. But in the Prop 209 case, they actually upheld it. And so California did not have affirmative action programs as they had in the past anymore after that time. Then we had some really famous cases in Michigan. In 2003, we had this case, Grutter versus Bollinger, and Gratz versus Bollinger. Bollinger was the president of Michigan University. And what it said is that in the undergrad case, which is Bollinger case, they had this formula, and you got a certain number of free points for being black or a minority. And they said that was not constitutional, that was too formulaic and quantitative, and that those kinds of formulas were unconstitutional. But in the Grutter case, the Gratz versus Bollinger is the undergrad case with formulas, not constitutional. The Grutter versus Bollinger case was the graduate level school, the graduate school, and they were letting people in and using affirmative action, but on a very holistic, it was just one of many factors. And the Supreme Court liked, actually, that admissions process. The justification the court used for allowing affirmative action shifted during this time period. In the past, it had been about making up for past wrongs that had happened in history. What we see starting in 2003 is a justification in the court about needing diversity in our colleges so that we could better prepare the leaders of the future. And we needed to make sure that those leaders were diverse since the country was going to be increasingly diverse. So that was the justification the courts used for that. All right, let me just kind of browse through here and see. That sums up civil liberties and civil rights. Let me just browse through here and make sure that there's nothing we haven't talked about that I think is important to talk about. Nope, I'm good. I'm not sure that I have anybody who's actively watching to see if there's any questions, but I'll pause for a second just to make sure. Okie dokie. Well, I think that as long as you remember civil liberties and where they're derived from, and then that civil rights come from the 14th Amendment and has two sections, the due process part and the equal protection part, then and don't drive yourself too crazy with these cases, that hopefully you can reason your way out of whatever box you find yourself into. Oh, yeah, the Korematsu case. So Campbell wants to know how they managed to justify the Korematsu case. And it doesn't stand up great now, but it was something about, I forget the phrasing they used, but the idea that we had to protect national security above all, that was like the most basic level of government was to provide for the common defense. And that in a time of war, we couldn't really be too cautious about that. But it is of note, it's the only case in which we've ever paid reparations. Like, we paid money to the people in the 1980s. They apologized and paid money to the Japanese people who were interned. It was only $10,000 that was paid to them, and they lost their homes and their businesses. So I don't know in World War II money how much money they lost, but I doubt that the $10,000 in 1980 probably made them feel all even Steven about that. But it is the only case of reparations that I know of that's ever been paid in federal government. All right, are there any other questions? Okay, so I'm going to be back on Periscope tomorrow night at 7 to go over all of the elections, linkage institutions, media, campaigns, nomination, that stuff. And so that'll be the last gasp before the test on Tuesday. There's lots of different approaches to this, but I definitely would recommend that you sleep well on Monday night, because sleep is really important. So whatever you can do tonight and tomorrow until 8 or 9, great, but I do hope you'll be well rested for the test. And just remember that you're just trying to do better than the other people taking the test. You don't need to try and make 100% on the actual test itself, okay? Because it sets a pretty high standard. So I hope this has been of some use to someone. If anything, my conscience is clear that I've done the very best I knew to do with time to help you all prepare. So good luck. I'll see you tomorrow night if you're able to tune in. If not, all the links will be posted on YouTube.